From dual citizenship to the Genome India project. Today we have some really good articles to study as part of our daily news analysis. So hello, welcome to Narana's Academy, and here we are going to discuss the most important articles from Hindu and Indian Express which we consider very relevant for the examination. So before we start, just a key quotation. Ethics is knowing the difference between what you have right to do and what is right to do. Now, similar kind of quote was already asked in your previous year question in ethics paper. You should know that when we talk about a right to do, that means what all a human being can do. Well, we can do anything. We can do good things also, we can do bad things also. So when we are talking about right to do, it is about the freedom we have, the absolute freedom we have. And with absolute freedom, we can do whatever we want to. We can even kill someone. But what is right to do? That is the second part. So what can be considered as right thing to do? What is wrong and what is right? When you understand the difference between the freedom that you have in an anarchical way, what all you can do, but what is exactly right thing for you to do, or what is we call as ethical. So this quote is just giving you a motivation to understand that what is exactly right in life. So any decision, any action you take, is it right or it is not right? This is something we need to consider, and one who knows this difference, that person is called as an ethical person. Okay, so before moving ahead with our topics, just a brief introduction about the courses in Narayana's Academy. So right now the admissions are open for the 1 year as well as 2 year course. Those who are going to attempt in the year 2026, they can go for 1 year course, and those who are going to attempt the exam in 2027, they can go for this 2 year prelims cum mains integrated course. Now this course is designed in such a way that more than 800 hours of GS as well as CSAT lectures will be there, and more than 200 hours of current affairs lectures will be there. Apart from that, you will be provided with a strategic micro schedule. Now this micro schedule is based on the UPSC syllabus. The syllabus has been described in detail so that we can cover each and every aspect that can be asked in the examination. So we'll be following this micro schedule throughout your course. Then we will be having a regular testing mechanism. So you will be giving more than 400 prelims practice questions which you will be solving, which will be evaluated, more than 1000 mains practice questions which you are going to solve, and we will evaluate that. Then apart from this, you will be provided with the study kit which will include NCERT Navigator books, total 12, and GS Navigator books, total 21. So these books are made in such a fashion that all the syllabus from prelims to mains, everything gets covered. Also you will be having access to digital resources, so more than 250 plus model answers will be provided to you, and there will be a monthly Navigator magazine to take care of your current affairs part. You can revise and you can cover up each and every aspect that is expected in the examination from these magazines. So this is the overall course. Now let's start with our daily news analysis. So we have picked up total 4 articles for today. So first article is related to accessibility. Now this article is related to persons with disabilities, and recently some provisions with respect to the act and the rules related to persons with disabilities are being discussed. So we'll understand it in detail. Second article is related to human genomes. So recently government of India has launched the human genome of 10,000 people in India. So it's a very good achievement for India. Third article is related to Bharatiya Nyay Sanhita section 152. So right now we are talking about the idea of sedition, which was earlier there in the Indian Penal Code, but now it is part of BNS, which is a concerning thing. So we are going to discuss that. And the last article is related to dual citizenship. Is dual citizenship allowed in India or it is not allowed? This is being discussed by scholars. Okay, so let's start with our first article of the day. We need accessibility rules that are based on principles. So the point is, we are going to discuss this particular act, Right of Persons with Disabilities Act, which is important for prelims as well as mains, and you should understand the idea of accessibility which is being discussed again and again. Okay, in mains GS paper 2, welfare schemes for vulnerable sections, PWDs are vulnerable section, right? Look at this previous year question. The Rights of Persons with Disabilities Act 2016 remains only a legal document without intense sensitization of government functionaries and citizens regarding disability. Comment. So they are saying you have made a law, but the law is completely useless. This is what the question is trying to say. And you might need to attempt such question in future too. So you should have a brief idea. Now what has happened recently? Recently, Supreme Court gave a judgment in this case, Rajiv Raturi versus Union of India. In this case, Supreme Court struck down or cancelled a provision, that is rule number 15 mentioned in Rights of Persons with Disabilities Rules 2017. Now these rules come from the Rights of Persons with Disabilities Act of 2016. This act was brought in. After that, these rules came, and under these rules there is rule number 15 which is cancelled or struck down by Supreme Court in this case. Now why it is cancelled out by Supreme Court? Because Supreme Court is saying the act we had brought in the year 2016, and if you check the rules of 2017, there is some discrepancy, there is some difference. This rule 15 is not exactly based on the idea that was proposed in the act. It is different from the act. So that is why government Supreme Court is saying we are cancelling it out. So now to understand all these complexities, we need to know what is this rule 15, what is this particular act, what are these rules. We need to have that idea. First of all, let's understand the condition of persons with disabilities in India. Now when you say persons with disabilities, a person might be having some physical issues. For example, let's say there is issue with the eyes, there is issue with the legs or anything. So when we are talking about such people, if you look at their population or their contribution in the population numbers. So census data of 2011 says in India we have total 2.68 crore persons with disabilities. Now although it's a old data, we are still waiting for the next census. We don't have an updated data. So we can look for another data which comes from this National Family Health Survey 5. This data says 4.52% of the population of India is having some kind of disabilities. Okay. So if you're writing answer, in the answers you can quote any of the data. Apart from these two, we do not have any authentic data to quote. Okay. So approximately we see somewhere around 5% population of India is disabled. So a substantial chunk we can say. Now, if you look at this population, if you look at the educational status of this population, we see that more than 45% of this population is illiterate. They can't even read and write. We're not talking about any higher education, just reading and writing, very basic stuff. But almost 50%, 45% is almost 50% population is illiterate. 62%, which are in the age group of 3 to 35, they have never attended any school, neither primary nor any secondary, nothing. So you can understand the gravity of the situation or how much serious this issue is. Then look at the employment. See, if you look at the entire number, now there, let's say there are 100 people who are persons with disabilities. Not everyone will be in a position to be employed. Let's say someone is a child, someone is at old age, they might not be in a position wherein we can say that they are employable, they can be given a job. We are talking about those who can be given a job, they are capable. So total 1.3 crore people are employable. Out of that, only 34 lakh are actually employed. Now this is an interesting data. 1.3 crore can be employed, but they have not got the employment. That means in our institutions, in the private companies or government sectors or anywhere, there is some problem. People are not giving employment or job to the persons with disabilities. That's why we see only 34 lakh are employed. And also there are some problems like minimal workplace accommodations. So for example, such a person might require some additional infrastructure. Let's say some kind of restroom is required, or the building has to be made in the manner which is very much friendly for persons with disabilities. It is not there. That could be one of the problem. If I talk about the infrastructure part specifically, only 3% of the buildings in India are made in such a fashion which are clearly accessible, fully accessible to the persons with disabilities. Now, this is the worst data I can ever quote anywhere. Only 3% buildings. And this is the data given by Department of Empowerment of Persons with Disabilities in the year 2018. Right? Then something on digital sphere, 98% of the websites, they fail accessibility standards. So a person with disability is not in a position to even access this digital world, which is becoming larger with time. Overall, all these data are showing that the current status of persons with disabilities is very, very bad, very, very serious, very, very aggrieved they are, we can say. Now, what are the challenges they overall face? Although the data is already telling us what are the challenges they are facing. For example, they don't have accessible infrastructure, the kind of infrastructure needed to access anything. For example, if you look at the public transportation system, is it completely accessible to persons with disabilities? That is being questioned. Then if you talk about education, there they are excluded. Around 50%, if they are not getting any kind of education, means they are excluded. They are not getting job. There are barriers in the employment. In the healthcare also, many a times we see in the healthcare facilities, in the hospitals, the required machineries or devices or assisted devices, they are not available for the persons with disabilities. Many a times we see this issue. Then digital divide, we talked about the websites, they are not accessible. And there is implementation gap. What is the implementation gap? In India, we already have an act which talks about so many things to provide infrastructure, education, health, all these things to be provided to persons with disabilities. For that, we brought this Act of 2016, Rights of Persons with Disabilities Act. But the act is not implemented in letter and spirit. So there is implementation gap. Okay. Now, let's just understand what is exactly mentioned in this particular act. Now, first of all, the act has provided the definition of what do we mean by persons with disabilities. Although this definition was already present, but it was a brief definition and all the disabilities were not part of it. So, in this act, the disability definition included total 21 disabilities. So, it includes many things. Then it talked about reservation. So in the government job, 4% reservation is given to persons with disabilities. In the higher education, 5% reservation is given, and this includes your private institutions also. Now, you might say it's just talking about higher education. Well, as far as the primary education is concerned, it is already taken care of by the government. For example, free education is provided in the age group of 6 to 18. So, nothing to worry about educational. Then this act also talks about barrier free access. If there is any public space, let's say government office, government hospital, or let's say government transportation bus, anything. For any such public space, that space should not have any barrier for a person with disability. So you should have all those mechanisms, all those devices, whatever is required to make it persons with disability friendly. This is what this act specifically says. Then specific pensions are also provided to persons with disabilities. And there is one interesting concept used in legal terms which we call as limited guardianship. Limited guardianship. So usually when we talk about guardianship, we think about our parents or someone who is replacing our parents, who are taking care of us. They are called the guardians. So the concept is whenever a person who is disabled or Vikalang, that person can take help from a guardian, and both of them can go ahead with any legal support. So let's say a person with disability want to go ahead with any legal action, if they want to take any benefit from the government, anything. For that, it is not necessary that only that person has to come and sign and show his face. Their guardian also can play a key role. So it's like a joint mechanism wherein your guardian will be taking care of you, so they may represent you many times. Then there are special courts made for persons with disabilities, and in case you are facing any kind of discrimination, you can directly reach out to these courts and you will be penalized. There are special penalties, special punishments given in case of any kind of discrimination against a person with disability. Clear? Now, so we were reading the news. In the news, we saw that there is this case Rajiv Ratori versus Union of India, recent case, wherein we said that Rule 15 under the Rights of Persons with Disabilities Rules 2017, this has been said as unconstitutional or wrong or invalid by Supreme Court. See, usually what happens, first act comes, that is Parliament will be passing a particular law. After that act, some rules are specifically mentioned by the policymakers. Rules are made. And we expect that the rules should be exactly aligning with the act. Whatever is mentioned in the act, your rules should also align with it. It should not be contradictory to the act. But here, something else is happening. So if you read Rule 15, it says that when it comes to accessibility, we want to make things accessible to persons with disability. So what government does, the ministry or the departments, they give guidelines to all the organizations or the private companies or the citizens. They can give guidelines. This act, the Rights of Persons with Disabilities Act, this act clearly said that there should be mandatory provisions. Government should give mandatory guidelines. But what happened with the rules? Rules are contradicting. Rules are saying that these accessibility guidelines which will be provided by ministries or departments, it is not mandatory. It is discretionary. That means ministry will decide on its own whether to make it mandatory or whether not to make it mandatory. Now this very small provision, this is now questioned by Supreme Court. And Supreme Court has clearly said this violates the fundamental right of these persons with disabilities, and they have given direction to the government saying that you have to make it completely mandatory within next 3 months. Okay, so this is the exact news which we can understand now. Now for better answer writing and for also better understanding of this issue, we should know that it's not like government is not doing anything. There are many government initiatives which support the persons with disabilities. For example, we have Accessible India campaign, which was launched to make all the public spaces accessible to persons with disabilities, which includes transports, public buildings, etc. Then we have brought our Aadhaar, and in Aadhaar we have a specific number which is very unique for every individual. Similarly, there is unique disability identification project, just like Aadhaar project. So a unique number, a unique card is provided to a person with disability. So this is their digital card. And just like using Aadhaar, now we are getting several benefits. Many people are getting direct benefit transfer from government. Similarly, this identification will allow that person to get benefits which he or she is supposed to get. Then we have this PM Daksh. Now through PM Daksh scheme, government is providing skill development. So some kind of training is provided to these people so that they become capable of getting job in the market. So employability is what being focused over here. Then Deen Dayal Disabled Rehabilitation Scheme. Government does one more thing. They give some grant, some amount of money to the NGOs so that these NGOs can do something for the welfare of persons with disabilities. So under this scheme, government is giving grants to NGOs so that they can work for education, rehabilitation of persons with disabilities. Then there is ADIP scheme. Under this scheme, wherever we observe that some people require some devices for their help. Let's say there is a person who is not having his legs, so he might require some kind of a stick or anything, any kind of device that can provide some kind of assistance. Such devices are called assistive devices. So to get such assistive devices, you will be provided with some aid, financial aid by the government under the scheme called ADIP. So all these are Indian government initiatives, right? Now at the international level also, we have some initiatives. For example, we have United Nations Convention on the Rights of Persons with Disabilities. Now, India has already ratified this convention in the year 2007, and the convention simply says that persons with disabilities should be in a position to enjoy each and every human right that they deserve. There should not be any kind of discrimination. And even Indian laws are very much aligned with this convention specifically, right? Then we have this Incheon strategy. Now this strategy was adopted in the year 2012 by United Nations Economic and Social Commission for Asia and the Pacific. Now very similar to this convention, this strategy says that we should have our development which is disability inclusive. Right now we talk about inclusive development, that everyone should be part of the development, and when we are saying everyone, disabled individuals should also be part of it. They should be participating in your development, in your growth, etc. And now just to conclude our article, because we have already discussed the challenges these people are facing, they are very vulnerable and something government has to do. Already initiatives are going on. As a way forward, we can say that these are the areas where we need to focus. For example, first thing is the infrastructure part. We need to strengthen the infrastructure. Second is the education and employment part, because here they will feel empowered. Third, to make things more accessible, especially in the digital arena, because digital world is rapidly booming, and here we need to make digital stuff accessible to persons with disabilities. And also more important thing lies with our societal perception. In society, if a person is divyang, he is treated very badly. Many a times people even make fun of the terms which we use to describe a person with disability. So we need to change the societal perception, the mindset of society towards these people. One thing additionally what we can do is we can make use of technology. So for making some devices for these people, or let's say you are making use of artificial intelligence. We are saying digital world is not accessible to these people. So what we can do is make use of artificial intelligence, make use of the technology so that you remove that digital divide which exists right now. And also wherever required, the legal and policy implementation has to be done. As we said, that act is not implemented in complete spirit, that has to be made complete, that has to be implemented. So this is how we can understand the status of rights of persons with disabilities. Okay, now before we move on to the next topic, let me check if we have any comments or any doubts. Okay, there are no doubts. So let's start with the second article. India releases compilation of 10,000 human genome from 83 population groups. Now this Genome India project is very important for you to understand. But to understand this, you need to know the chronology through which these projects came into picture. And you need to know what is this genome also. It's important for prelims as well as mains. Now look at this previous year question. You can read this question. I'll give you just 10-15 seconds. Please read. So if you have read the question, it talks about genome sequencing. Now, unless you know what is genome and what is genome sequencing, I don't think anyone can actually attempt this question, right? So let's understand everything. So on this date, January 10, 2025, what Government of India did, they have launched Genome India Database. This database includes the genome which is already sequenced of total 10,000 individuals in India. Now I know you're not getting anything. So let's go to the basics first before we understand the news. What is genome? I hope at least you know that there is something called DNA. We have DNA in our body, not just body, we have cell. In the cell we have nucleus. In the nucleus you have this chromosome, and in this chromosome you will be having your DNA or genetic material. So when you talk about DNA, in that DNA we say that all your genetic information is stored. So let's say your hair are black, your eyes are brown, whatever it is, all this information is already stored in your DNA. And it's not like you have only one DNA. There are so many DNAs. There's thousands and lakhs and crores. Now, if you look at this particular chromosome in which we are saying this DNA is present, this DNA, if you see the structure of this DNA is having a specific order, a specific sequence of these bases, which we call A, T, C, G nucleotide bases. In simple, you can understand, if you look at this diagram, we are saying this is in a specific sequence. Just like after A, B comes, or if you're writing a book, there is a specific sequence in which it is written. The chapters are in sequence. In the chapter, the statements or the words are in a particular sequence, right? So now we are saying, if there is a person, if you can understand the entire DNA of that person, let's say in my body, whatever DNA is present, if you can understand entire DNA, if you can understand entire sequence of this ATCG present in the DNA, then you can understand each and everything about that person. So this is what we call as genome sequencing. Genome is nothing but complete genetic material. Entire DNA, entire stuff of your genetic material, everything is present in this genome. When we say genome, we are talking about this entire genetic structure that you are having. And when you are talking about genome sequencing, here you are ensuring that these ATCG bases, they are present in the right or exact sequence. So if there is a scientist, let's say I am a scientist, I want to know that why this is a person who is having a specific rare disease. So what I'll do is, I'll get entire genome of you. I will sequence it in the right manner, the manner in which it is present in you. After that, I can study. I can try to know why this person is having this disease. Then also I can try to understand how I can solve this issue also. So I can make specific medicine which will be applicable to you only, which will treat you only. So here we are saying that this genome sequencing is going to help us a lot. Now you can understand one basic stuff, that you are very much similar to your parents in some things. Let's say your eyes look like your father. This is possible. This is possible because some of the genes have become have come to you. You have hereditated, or what we call as, in simple terms, there's something called heredity. So you have inherited you have inherited those genes from your parents, but you are not exactly similar to your parents or your brother or sister. There is variation, and if you look at all the species, they have some variation, some difference. So everything is happening because there are some differences in genes and in DNAs. So when you study this genome, you can say this genome is like entire book, entire book. You are a complete book and we are studying you completely. Okay. So if you do the genome sequencing, that will be helpful. Now, how it will be helpful? Let's say in the biomedical research, you want to study a particular genetic disease, then that can be identified very easily, that why this person has this disease, how this disease came. Then if you know the problem, you can also go for the solution. Let's say you want to make a specific drug, a specific treatment, or we call it precision medicine. Sometimes we use this term, precision medicine. So we want to make a medicine which is precisely necessary for you only. Let's say there is a medicine which works on European population but not on Indian population. So we can make something which is very much applicable only for Indians. So this we can develop. Then in the agriculture, let's say you want to make disease resistant crops, GM crops. When you do genetic editing, genetic modification, for that also this genome sequencing will be very helpful. Then evolutionary biology. Let's say you are studying genetic diversity, different species in the world, their reproduction, all these things you are studying. But to understand their gene and different kinds of genes, how they have evolved, all that is possible if you have the sequencing available. Then to conserve your species. So there is a species which is going to get extinct in next few years. So you can study their genome sequence. Why only this species is getting extinct? Is this species very weak, or there are some genes which we can make use of to preserve this particular species? All these things are possible with genome sequencing. Okay, now who does the genome sequencing? Obviously the scientist who will be working in the biotech field, they'll be doing this. Now, this study or this genome sequencing started with a project called Human Genome Project. So, you see, this project actually started in 1990, which worked till 2003. Then 2009, they also made some advancement in that field. So, it was a worldwide project. So, what they did, they took samples of somewhere around 20,000 to 25,000 people, different genes, and they worked on it. They tried to sequence complete genome of these individuals, and the samples they took were the samples from different locality, so that you can understand entire population. But there was one problem. If you look at Indian population, hardly there was anyone who was part of this human genome project. So even if you have conducted this study, we can't call it a comprehensive study, and we can't call it a study which is highly correct from Indian population perspective, because we were not part of the studies which were conducted or the population sample which was taken. Indians were not part, or Asians or Africans, they were not part. Mostly it was Western dominated. Then what we did in India, we started Indigen project in 2019. So we made use of this data which we got from Human Genome Project, and we started creating the data for Indians. So here this was launched by CSIR under Government of India. After that, in 2020, Department of Biotechnology launched this Genome India project. Now, this is one of the most important project India has ever worked on in the field of biotechnology. So what government did, or this organization, 10,000 individuals have been taken up. Now these 10,000 individuals do not belong to any one area, rather they represent entire India. So different people from different locality, different kinds of genetic diversity, they have been taken and their genome has been sequenced completely. So the data has been stored at Faridabad, and the population includes total 83 different groups. Now, how this is going to be useful? We talked about precision medicine. Here it will be useful. But apart from healthcare sector, it is important for our economy. Right now, biotechnology is one of the booming sector, or what we call it as sunrise sector. You see, in 2014, you see it was $10 billion, the size of the economy of biotechnology sector. It was just $10 billion. By 2024, it is $130 billion. So you can see the kind of growth is very, very good. So this project will be very helpful for the private organizations, for our economy. Then it will be very helpful for the global research also, because when Indian scientists are coming up with some data of Indian population, that will be a good sample for the researches that are being carried out at the global level. Okay, so this is all about Genome India project. So if I go back to the context, now I hope you understand the context that we have launched the Genome India database. All the 10,000 people, we have already done whatever sequencing we had to do. Now we have completely said that this is the database we have, we are launching it, we are making it public. So this is what government has done. Clear? Now just a break of 10-15 seconds before we move on to the next article. So I'll check if we have any comments till now. Okay, no doubts. Fine. So the next article is section 152 of BNS should not become proxy for sedition. We need to know what is sedition. We need to know about Indian Penal Code and specifically section 152 of BNS. Now this is important for prelims as well as mains. In mains GS paper 2, we talk about the functioning of executive, and here the role of executive becomes important. Even the role of judiciary becomes important. Look at this previous year question. Discuss section 66A of IT Act with reference to its alleged violation of Article 19 of the Constitution. Now whenever there will be any clause or any act which is very much contradictory to the constitutional values or constitutional principles or the fundamental rights, UPSC will be focusing on that. So here they are focusing on this particular clause of this IT Act. Similar question can be asked about section 152 of BNS. Okay. Now see what has happened recently. So if we go to Rajasthan, so Rajasthan High Court, there was a case going on in Rajasthan High Court. The name is Tejinder Pal Singh versus State of Rajasthan. Under this case, Rajasthan High Court said that we have this section 152 of BNS, and there it seems that this provision is now going to be misused by authorities. And to avoid this, we need to have specific clarity on the sedition provision. Now what court was specifically saying that in India we have a democracy. In democracy it is very obvious that people with different viewpoints, with dissents, they can speak whatever they want to. But if there are some provisions which can be misused against such dissent, that is very dangerous. If you are criticizing government or a politician or an authority, you might be charged with sedition. Sedition is in Hindi we call it Rajdroh. So you are taking an action which is directly against the state, against the sovereignty of the state, or you are doing something which is harmful for the entire country. Such kind of serious crime is being considered. But what the court is saying, if we have something like section 152 of BNS, although the word sedition is not mentioned in this, but authorities can interpret it that way and misuse it and put this clause on anyone just because they don't like that person or they don't like their opinion. So there is a potential. Now first we need to understand this section specifically, then we'll get a brief idea. So section 152 of Bharatiya Nyay Sahita, it criminalizes the acts that incite secession. Now secession, let's say Kashmir wants to become independent, then that demand will be considered as demand of secession, that we don't want to be part of India, we want to become a separate country, independent country altogether. This demand is called secession demand, and if anyone, any political leader or any person who is trying to make people go ahead with secession, he's protesting or he's going ahead with some propaganda or whatever he's doing, in that case such action will be considered as a crime under this section 152 of Bharatiya Nyay Sanhita. And it's not a normal crime, it's a cognizable offense and non-bailable offense. Cognizable means it's a very serious crime. For not so serious crimes we call it non-cognizable, but it's a serious one, just like murder. It's a serious one, and you will not be getting any bail if you are charged under this provision. Now we said that the term sedition is anyway not mentioned in this. Okay, but the provision is very much similar to what was there earlier in the section 124A of the Indian Penal Code. See, Bharatiya Nyay Sanhita, this is brought very recently by the government. Earlier we had Indian Penal Code. We have reformed the system, we have brought new criminal laws, right? So we had brought some laws directly which were part of this IPC into this Bharatiya Nyay Sanhita. Some we have removed, some we have changed, modified. That was the reform. So first we need to know what was there in this section 124 of IPC. So section 124, it was introduced in the year 1870. So this means in the British time period this was introduced. And why Britishers introduced? Because they didn't like anyone talking against British Raj. So anyone who was talking against British Raj, what the authorities will do? They will put the charge of sedition on these people and they'll be put in the jail or they'll be given very extreme punishment. The first person who was given punishment or convicted under this sedition law was Bal Gangadhar Tilak in the year 1897. So it's not just Bal Gangadhar Tilak, but many other leaders were also charged with sedition. So when our independence struggle was going on, at that time it was being said that we'll not have such provisions in the constitution or in our laws. But well, the story is very different. Now if you look at this section 124A, it defines what is sedition. So I have a slide to show you this particular provision. So it clearly mentions that whoever by words either spoken or written or by signs or by visible representation or otherwise brings or attempts to bring into hatred or contempt or attempts to excite disaffection towards the government established by law. So if you're doing anything which spreads hatred against the government of India, then that is being considered as sedition, and then you will be given imprisonment, let's say up to 3 years or whatever has been mentioned over here. So in simple terms, I'm saying it has given the definition of sedition. The most important thing about this particular section 124A is that it is misused a lot. Whoever is in power, they make sure that they use this provision just to ensure that nobody is opposing them, nobody is criticizing them. If someone is criticizing a lot, they'll put this sedition provision, they'll charge them under this, that person will be in jail. So this was misused a lot and there was potential to misuse again, and this was shown in particular data also. I can show you the data. Let's say you see this particular data from 2015 to 2020, total 548 sedition cases were registered and people were arrested. 548 people were arrested. Now later on when they went on to the court, the case continued, only 12 people were convicted. What does this show? So many cases and conviction rate is very low. That means authorities were actually misusing, and all these were fake cases. Most of them were fake cases, at least this is what we understand. So this misuse was completely visible. So in the year 2022, Supreme Court suspended all the sedition related cases, petitions, trials, everything. Court said that we should stop all of this. At that time, what Union Home Ministry said is that they are going to bring in new law, or they are going to repeal, they are going to completely take away that sedition clause from the laws. Later on, we saw that BNS, Bharatiya Nyaya Sanhita, came into picture. But interestingly, if you look at the section 152 of Bharatiya Nyaya Sanhita, it seems what the Union Home Ministry at that time said, that we are going to remove sedition related provision. They haven't removed it. Rather, it is a rebranded version of the same clause which was there in the Indian Penal Code, section 124A. Same has been added in the Bharatiya Nyaya Sanhita in the form of section 152. So here you can see this section 152 clearly. If you read, it mentions that use of financial mean or otherwise which excites, attempts to excite secession, armed rebellion, subversive activities, encourages feelings of separatist activities, etc., etc. Here there is this term called endangers sovereignty or unity and integrity. Now this is a very vague term. Just it has been mentioned that if someone is endangering the sovereignty or unity of India, well, which activity will be called as something which endangers unity of India? We don't know. Authorities will be now interpreting it on their own, and that interpretation could be anything. So again, there is complete scope for misusing this provision, and again charging people with sedition using the same clause, that is section 152 of Bharatiya Nyaya Sanhita. Okay. So overall, we talked about this definition part. Now this will have an impact on the free speech. We have Article 19, freedom of speech and expression. But if people will be charged with this sedition laws, then there won't be people who will be speaking what they think. There won't be any dissent, and the democracy will not remain democracy. Right? So this is all about this BNS provision. Okay. Now, the next or the last article of the day, that is related to dual citizenship in India. So do we have dual citizenship or we don't have? That's the basic part we are going to study here. It's important for prelims as well as mains as part of GS paper 2 Indian Constitution, its evolution, its features, etc. I suggest you to please read this particular question. You'll understand which topic is important for the examination. So please read. Done? So the question specifically is talking about the citizenship part. So if you look at the Constitution of India, the part 2 of the Constitution specifically deals with citizenship angle, and you will have to read it as part of your static. Here we'll specifically deal with dual citizenship because it was recently in news. So recently Dr. S. Jaishankar, External Affairs Minister, he was discussing about this idea of dual citizenship. He said, we are thinking about it, but it's very challenging to bring in dual citizenship in India. He was discussing all those challenges, but he said that this debate is still alive. So he's not saying that we are completely going against it. The debate is going on, it's still alive. We have some challenges. So there's no clarity whether India is going to allow dual citizenship or whether we are not going to allow. So we are saying there is a debate going on right now in public sphere because of this statement by Dr. S. Jaishankar. Now, first of all, what is dual citizenship? Is it allowed in India? Dual citizenship means you are citizen of one country, let's say India, as well as you are citizen of some other country, let's say United States of America. Is it allowed? Is it allowed? So if you see the constitution, it doesn't seem it is allowed in India. Indian constitution clearly says we have only single citizenship provision, and we will not allow any person to become member or citizen of two different countries, India as well as through some other country. So if you read the Citizenship Act and the Constitution, the Citizenship Act of 1955, as well as Article 5 of the Constitution, So this is the Article 5. What it says, at the commencement of the Constitution, when the Constitution came into picture, every person who has been domiciled in the territory of India and who was born in the territory of India, you were born in India, or either of whose parents was born in the territory of India, or who has ordinarily resident in the territory of India for not less than 5 years immediately preceding such commencement. So these are the provisions clearly mentioned in the Constitution, Article number 5. And if you read the Citizenship Act of 1955 also, overall what you understand is that Government of India does not allow any kind of dual citizenship at all. As soon as any person who is having citizenship of India, he goes outside and he takes the citizenship of other country. Let's say I have taken citizenship of United Kingdom. If today I have taken that, so as soon as I take this citizenship, my Indian citizenship will be completely gone. So government will clearly say that now you are not the citizen of India. So this kind of restrictive provision, conservative provision you may say, but this is what is already mentioned in our constitution and in our act. Okay. Now people get confused with these three terminologies. Sir, what is NRI? What is PIO? What is OCI? So let's have a brief understanding. When you say a person is NRI, that is non-resident Indian. Who is non-resident Indian? A person who is Indian. His citizenship is Indian citizenship. Let's say I am living right now in India, but now I thought that I'll go to United States for a job. So I went to USA and now I'm living in USA only. But my citizenship is not US citizenship. I'm just doing my job over there. I'm earning money. So my citizenship is Indian citizenship. Such person is called as non-resident Indian. His nationality is Indian nationality. So will I be having right to vote in India? Yes, I'll be having. I'm the Indian person. I'm having my passport with Indian nationality. Such person is NRI. Do I need visa to come back to India? No, I'll not require that. Can I own property in India? Yes, because I'm a normal citizen of India. So overall, I'll be having all the rights that a normal citizen of India gets. Now, as far as taxation is concerned, so I'm living in USA, I'm earning in USA, so mostly the taxation policy of USA will be applicable. But let's say I have something in India also. My business is also there in India. I'm earning some amount of money there in India also. So that money will be taxed in India as per Indian laws. So this is all about NRI, that is non-resident Indians. Now there is another concept, that is the concept of PIO, persons of Indian origin. Now we say that there are many Indians who are there spread in the world, especially if you look at USA. There are so many Indians who are even now so much powerful also. Economically they are good. They are head of many big corporations. Some are now even becoming part of the politics also. So many of them are persons of Indian origin. That means they are not really Indians, but their parents were Indians or their ancestors were Indians. They are just having the origin in India. Now they are not Indians. So such people, we call their citizenship as a foreign citizenship. They are not citizens of India. So they will not be given all the rights which NRI are given. So they won't be having voting right in India. They cannot hold the office, any kind of office in India. Let's say they want to become president of India. Not possible. Then they cannot hold agricultural land in India. But because they are persons of Indian origin, they are given some kind of visa to stay for a longer duration in India because they are having Indian origin. They can even own some kind of property in India, but not the agricultural land. And this is valid only for 15 years. This was being said under the policy of this PIO. Now this was brought in. Later on, this PIO was merged in a new concept that is called as Overseas Citizen of India, that is OCI. So we can say this PIO concept is now scrapped. Now we have something called OCI. Very similar again. The people are not Indian nationals, they are foreigners. They won't be having any voting right as such. What they can at max do is they'll be given lifetime visa. If you have this OCI card, You can come to India, stay in India for as long as you want to. That is allowed. Can you own any property over here? Yes, but again, not the agricultural land. And this will be valid for lifelong. So this is important, that it's not for just 15 years, it is a lifelong thing. So if you have got OCI card, that means you can come anytime, you don't need to renew it as such. Now, even if we are providing this OCI cards, still we are not saying that you have got dual citizenship, because we are saying you are still a person who is citizen of that country and not India. We are just providing you extra benefits because you are a person of Indian origin. So now, why we are concerned about dual citizenship? Why we are not providing it? First thing is the political loyalty. So how can a person be loyal towards its country if he is a citizen of two different countries? You are citizen of America also and India also. So towards whom are you loyal? So this is being questioned. Second, there are some security risk also. We know how many countries they will send their people, their spies, their agents to other countries, which may cause some manipulation in our country, so which can be a security danger or risk for our country. So if we allow dual citizenship, then that can be a security risk for our country. Other countries might be having a big influence in our policy making, in everything that we are doing, which is dangerous. Third, if we start allowing it, again there will be bureaucratic complexities, administrative mechanisms we need to bring, so many stuffs we need to do. Fourth, it's a populist stuff. Just because some people are right now calling for giving dual citizenship, that doesn't mean you will give it, because this can be misused very badly. And there is a recolonization concern. There is a term used by Marxist scholars, that is comprador class. This means there can be some people who work for the foreign interest and not the interest of India. So there will be people who will be given this dual citizenship. They'll work in the interest of the other country, not Indian interest. And again, it's very dangerous. So all these challenges lead us to say that in India we are not allowing any dual citizenship as such. Clear? So this is what it is right now. Maybe in future we might consider bringing this concept of dual citizenship. So we'll see at that point of time. Now the time has come for our practice questions. We have one mains practice question. Discuss the significance of Supreme Court's judgment in Rajiv Ratori versus Union of India in addressing accessibility challenges faced by persons with disabilities. So just significance has to be discussed, one part. Highlight the current status of PWDs. Second, major challenges they face. Third, and government initiatives aimed at ensuring inclusivity. So there are four different dimensions you have to discuss. So in the answers, you have to separately mention all these dimensions in detail. 250 words answer. So start with this particular case. You can set the context directly over here. And in the body part, you can write about the current status that they are having. So population status, employment status, education status, infrastructure they are getting, any data. Even if you do not remember all the data, at least some of that can be written in the answers. Challenges these individuals are facing, which we have discussed already in detail: infrastructure, educational exclusion, if they are not getting jobs, digital divide is there, right? Then significance of the judgment. So the recent judgment you will mention, what is the significance, what help it will be giving to these people, and then some initiatives you can mention as much as you can remember. Okay, and you can also mention some way forward if you have space, otherwise a small conclusion can be written, right? Now some questions from the yesterday's articles. So with reference to Chief Election Commissioner and other election commissioners, Appointment, Conditions of Service and Terms of Office Act 2023, consider the following statements. First, the Act regulates appointment process, conditions of service and tenure of Chief Election Commissioner and other election commissioners. Yes, it's a normal statement, nothing new. President appoints Chief Election Commissioner and other election commissioners based on the recommendation of a selection committee that includes Chief Justice of India. Now this is not the reality. Okay, earlier we had this provision that Chief Justice of India will be part of selection committee, but later on Government of India made some changes. So this is wrong. And as soon as you make the second statement wrong, so you are left with this. That means only B, 1 and 3 is the right answer. So if you eliminate this, you reach to this answer. Still, the third statement is also right. Leader of opposition in Lok Sabha is member of the selection committee. Okay. Now, Right to Information Act. The RTI Act mandates all public authorities to proactively disclose certain categories of information to minimize the need for formal request. That is true. This RTI Amendment Act 2019 allows government to prescribe terms of service for information commissioners at both central and state levels. This is also true. Now this is a factual question. Okay. So C, both 1 and 2 is the right answer. Now this is the homework for all of you. First question related to section 152 Bharatiya Nyay Sahita. Please attempt this question. You'll be getting links in the comment box. You'll be having links in the description box also. So you'll be directly reaching out to the website where you can attempt all these questions. So one question on Bharatiya Nyay Sahita. First, it's talking about criminalizing secession, armed rebellion, subversive activities endanger India's sovereignty. Second is talking about, unlike section 124 of IPC, this section provides a clear and specific definitions. So I would say a bit difficult question for you, but you can attempt. Second, about dual citizenship in India. So first, Indian Constitution does not permit it. Then Article 5, what it says, and overseas citizens of India, what kind of rights they are provided with. So this one is a very easy question. And the last, which of the following statements about genome and genome sequencing are correct? First statement says, talks about genome. See what is genome? A kind of definition they have given. Second statement about genome sequencing. Does it involve these nucleotide bases A, T, C, G, etc.? And third statement is about Genome India project, which we have discussed. So a very comprehensive kind of question it is. Unless you have complete idea about the basics and the current scenario, you can't answer this question. But now you can answer because we have discussed all of that. Okay, so this is all about the daily news analysis for today. We'll meet in the next session. Let me check if we have any doubts. No doubts. You explained so well. Okay, thank you so much. So we'll meet in the next session. Thank you so much for joining.